Well, allow me to start by thanking Gail, Marianne, Danny, the convention committee, all the volunteers that are Eagle Forum Utah, for all that you guys do to promote liberty here in Utah. I'm also grateful for this opportunity to be part of the convention today. My name is Jim Kerr. I'm the Executive Director of the Pregnancy Resource Center of Salt Lake City. And we are a Christ-centered ministry that works to meet the comprehensive needs of those confronted with unplanned pregnancy. We also try to help those who have had an abortion in their past, and we try to promote biblical values as far as sexuality. But what I'm here to talk to you about today primarily is the roots and legacy of the Roe v. Wade decision. Rightly so, the phrase "never forget" has been associated with the Holocaust, as millions of lives were wiped out by Nazi Germany before and during World War II. We should never forget that atrocity. But as years and decades have passed, fewer and fewer individuals are aware of what the Holocaust was, let alone who were the victims and perpetrators, and even how could such a thing happen. This collective amnesia is partly due to the human tendency to avoid unpleasant memories and topics. But it's also due to the growing narcissism of 21st century America, where anything that doesn't directly impact my life isn't worth my time. And if it is worth my time, can you keep it down to just a 30-second soundbite? Not only is the European Holocaust of the mid-20th century being forgotten, but so is the American Holocaust of the 20th and 21st centuries. Even though the number of souls lost within the American Holocaust dwarfed that of the European Holocaust. If you define the European Holocaust as being Nazi regime's genocide against European Jews, then estimates are that 5 to 6 million Jewish lives were extinguished. If instead you hold to a broader definition, one that includes all civilian groups that were targeted by Nazis in non-military actions, then the totals jump to 20 million. Whichever number you use. The American Holocaust of extinguishing life in the womb has already surpassed 58 million lives, and that was just at the end of 2015. And while many Americans are cognizant of abortion, fewer and fewer remember what began this onslaught against innocent life. Almost 44 years ago, on January the 22nd, 1973, the Supreme Court of the United States, by a 7-2 vote in the Roe v. Wade decision, ruled that a Texas statute which outlawed abortions except upon medical advice for the purpose of saving the mother's life violated the constitutional right to privacy of Norma McCorvey, or Roe in the citation. Now, some in this audience might be surprised to learn that 5 of the justices who voted in the majority were appointed by Republican presidents. 2 were appointed by Democrat presidents. The 2 justices who voted in dissension, one was appointed by a Democrat, and then the Republican presidential appointee, William H. Rehnquist, obviously was in dissent also. There are 2 important lessons we can draw from who were part of the majority and who was part of the dissenting justices. First, not all Democrats are pro-choice, even though the party in the election of 2016 took some of the most strident stance they've ever had in their party platform. Secondly, not all Republicans are pro-life. Not all Republicans are conservative. Not all Republicans, as we were reminded, are strict constructionists. I pray the second lesson will be learned by the Trump administration as they're thinking about who to appoint to the judiciary, because Republicans for decades have seen too many times Republican appointees not just fail to restrict and maybe even overturn Roe v. Wade, but actually move forward the agenda of those who are pro-abortion. Intriguingly, the majority said that they concluded that the right of personal privacy includes the abortion decision. Now, given the magnitude of this decision, this was a total shift in American history and American jurisprudence. And so you would think that you would find this clearly in the Constitution, this quote-unquote right to privacy. But the Supreme Court admitted that the Constitution does not explicitly contain a right to privacy. What they saw instead was some roots of this right of privacy. In the First Amendments, in the penumbras, I love that, the Bill of Rights, in the Ninth Amendment, or in the concept of liberty in the first section of the 14th Amendment. Well, let's take a look at some of those roots, but not necessarily in the order that they listed them. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects clearly points towards the existence of a right of privacy, as does the Fifth Amendment when it declares, "Nor shall private property be taken for public use without just compensation." However, these guarantees are not absolute, because if the government has probable cause, then one's security and privacy is diminished, or if the government can provide just compensation, then one's property can be taken for public use. Now, right there, that whole thing could be broken up into a lot of topics unto itself, but let's continue. What is exasperating about the court invoking these two amendments when considering this case is that the Fourth and Fifth Amendment were created to protect individuals from governmental invasion or seizure of their personal property. These amendments were never meant to prevent governments from deciding what is right or wrong, what actions can and cannot be taken by citizens. It was meant to prevent them from enforcing in such a way that took away the rights of citizens. But this case did not involve Texas eavesdropping on the appellant or wrongfully seizing her property so as to convict her of violating the law under review. This case was about whether Texas had the right to create this law. Therefore, even if we can agree that there might be some roots in the Fourth and the Fifth Amendments, we can't agree that they were applied properly in this case. Another source of roots of privacy can be found in the First Amendment, and we heard a little bit of that earlier. When it seeks to protect the basic freedoms of religion, speech, press, and assembly and petition, for any level of government is prohibited from interfering with our ability to read, think, communicate, believe, worship, or associate with others of our choosing. However, these fundamental rights also can be limited. For example, let's say there's a person who believes that it is important for them to have human sacrifices to their God. Okay? Now, in the United States, we would say you have a right to believe that. You have a right to talk about it. You have a right to try to convince others to believe as you do. But in the United States, you don't have a right to act on that. And why? Because to act on that right means you would take away someone else's fundamental right of life. Obviously, my illustration was chosen on purpose. So why did this court feel the roots of privacy were found in the First Amendment, where the applicable to Texas attempting to protect life by legitimately restricting another individual's right, a right that was not explicitly guaranteed as the First Amendment rights are, but instead was developed by finding inferences to such a right? I don't know. Regardless, the point is, even these fundamental rights are not absolute. And so when we continue to look at the Roe v. Wade decision, they made this point, that even as they were creating this new right based on some inferences on the right to privacy, they said even this right is not absolute. And I think that memo never got to the pro-choice camp, because they absolutely believe that the right to abortion is something that's a fundamental right and that it's an absolute right. But the court would not agree with that. Based upon this court's limited view about this new right, they created this trimester framework. And they held that the government, towards the end of a pregnancy, had growing legitimate interests in protecting the health of the mother and protecting the potentiality of human life. Potentiality of human life, what an intriguing phrase. The author of the majority opinion was very careful not to actually refer to a preborn child, as a human being, as a person, but instead chose language such as that or the sterile fetus. According to this opinion, the court was unable to determine whether a fetus was a person's, since the representative disciplines of medicine, philosophy, and theology are unable to arrive at a consensus. But the court, no matter what its claim might have said, could not avoid this central issue of, is the fetus a person or is it not? Whatever decision they were to make inherently meant they would make that decision on personhood. But What they did is try to avoid that. They didn't want to go to that step. And so what they tried to do is the same thing that the Supreme Court did in the Dred Scott decision back in the 19th century. They didn't want to recognize Dred Scott as a citizen because they knew if they did, that means they would have to protect his rights. So they didn't want to go down this road by actually referring to the unborn child as a person. And so when we look at the 5th and 14th Amendments, we come to realize why that was. In the Dred Scott case and Roe v. Wade case, the courts were fully aware of the 5th Amendment's explicit guarantee that no person could be denied the right of life, liberty, or property without due process of law. The 14th Amendment, though, coming after the Dred Scott decision, similarly says, nor shall the state deprive any person of life, liberty, or property. In both of these amendments, life is the first right listed. Property is the third. And so this concept that there's a right to abortion because there's a right to privacy, and that's kind of based on this concept of the right of property, it just doesn't make sense. Elsewhere in their 1973 decision, the court readily admitted if the suggestion of personhood is established, the appellant's case, of course, collapses. Think about that. If the personhood is established, then Roe v. Wade fails. It collapses. For the fetus's right to life would then be guaranteed by the 14th Amendment. No wonder they didn't want to refer to the child as a person. So even though there was no clear consensus that an unborn child should not be considered a person, the court chose to deny such recognition and thus condemn tens of millions to their death. Could you imagine a jury burdened with a death penalty case, informing the parties and the judge that since there was no clear consensus between the lawyers, they couldn't make a decision? Or that they might base their decision on their inferences of what happened and not the explicit testimony of the witnesses or the evidence submitted or the arguments made by the lawyers? It just doesn't make sense. The court also found evidence of a root for privacy within the penumbras of the Bill of Rights. Now, the word penumbra comes from the field of astronomy. It refers to an area wherein the light from the sun during an eclipse is neither fully visible nor fully blackened out. In other words, this right to abortion is not a black and white constitutional issue. It falls within the gray area. What a decision to make to condemn tens of millions to their death. According to this case opinion, another root was the privacy could be found in the 9th Amendment. And this by far is more defensible assertion than depending upon penumbras or misapplying other inferences to privacy within the Constitution. But there is also a problem with this part of their rationale. As you see, the 9th Amendment states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So beyond the rights listed in the Constitution, there are others, and maybe one of those is a right to privacy. Absolutely, we'll admit to that. But the 9th Amendment does not explain how do we determine whether it is a right or not. Most likely that's because the authors of the Bill of Rights, which include the 9th Amendment, fully knew that the 5th article of the Constitution provided the mechanism, that is, amending the Constitution. But that mechanism only allows one branch of the federal government to possibly be involved in creating new rights. And I can tell you now, it ain't the judiciary. Instead, Congress, which was originally comprised of representatives of the people and state legislatures, could begin this process, not the president or any other member of the executive branch, and not the judicial branch. There are 58.5 million reasons why the Roe v. Wade decision is one of the worst tragedies in American history. But one of those reasons did not include Roe's child. That's right. Norma McCorvey never aborted her child, but instead gave her up for adoption. Pro-choice supporters would respond that this case was never about her aborting her child. I think the Supreme Court would have been surprised by that assertion. Instead, it was just about having the right to choose if she wanted to or not. Today, Norma McCorvey describes how she was railroaded into being Roe and how she now is adamantly pro-life. What caused her to change her mind to no longer be an advocate for the right to abortion? Caring individuals not allowing the divide on this significant and tragic issue to prevent them from seeing her as a person and interacting with her in loving and caring ways. For a number of years, Norma worked for an abortion provider, but providentially, a pregnancy center such as ours moved into the same strip mall, and Norma eventually came to realize that some pro-lifers were actually loving, caring, and not hell-bent on convincing her she was wrong. The Pregnancy Resource Center of Salt Lake City attempts to do the same approach of not trying to convince people that they're wrong, but instead, as clients come to us and they have problems, as they're confronted with unplanned pregnancies, we try to come alongside them and try to listen to them. What is going on in their life? What challenges are they confronted with? We also try to help them understand that whatever their decision is going to be, that they make an informed decision. And also, whatever decision they make, that we will not judge them. We're not going to condemn them. We're going to continue to provide our free and caring confidential services to anyone who walks in our doors. And so those include medical services, counseling services, referrals, and material resources. Even the clients who, after receiving our services, believe that abortion is their best option, we don't cast judgment upon them, but continue to minister to them and make sure they know that we love and care for them just as much as if they had chosen life. But do not misconstrue that what I'm sharing right now diminishes where I began this presentation. We do need to never forget the American Holocaust, its roots, or the tens of millions of preborn children's lives that have been extinguished, or double that amount of the number of parents who have been negatively impacted by this right to choice. There most certainly is a time and place for pro-lifers to engage in the struggle for the hearts and minds of other citizens within the public square. And that doing this as we work towards reversing Roe v. Wade, or at least diminishing the destructiveness in its wake. But equally so, there's a time and place for reaching out to those whose lives will potentially be or already have been marred by abortion. Within the next couple of weeks, there are multiple ways that you can be both an opponent of legalized abortion and an advocate of individuals ensnared by the right to choice. First, you can signal to your children, family, neighbors, and broader communities that you live in your profound disagreement with the Roe v. Wade decision by participating in the March for Life being organized by Pro-Life Utah. Join hundreds of others in this peaceful demonstration to share the truth that the greatest human rights violation of our time, legalized abortion on demand, is not needed, is harmful to society. It is scheduled for Saturday, January 28th from 11 to 1, beginning at Washington Square, where a memorial will be erected for the 3,176 souls that were aborted here in Utah in 2015. And then it will culminate up at the Capitol. Second, you can support the Pro-Life Utah's legislative agenda. Mary Taylor will be speaking with us later today, and she'll be sharing what that agenda is. Another thing that you can do is you can go to that March for Life, and you can bring diapers or wipes, and those donations will be given to our clients through our center. And then lastly, you can go to our website, pregnancyresource.net, to research the many other ways that you can help make sure that we don't forget those impacted by the legacy of Roe v. Wade. Thank you for your kind attention.